House Bill 1980. I'm sorry.
I have a daughter who's overdue her name, and she says they can get it almost exactly.
Almost. Is the problem, yeah. All right. It says here you are Taran Champagne testifying for yourself and testifying against House Bill 1980. Is that correct?
That is correct.
All right, you may proceed.
My name is Taran Champagne, and I am against House Bill 1980. Child support, in my opinion, should only be intended for parents who are absent from the child's life and who are not fit, willing, and able. Not for those who have been removed from the child's life by either the state of Texas and the abusive family court system, or by a parent who's withholding the child from the other one due to whatever feelings they may have against that parent. The best interest of the child is purposely ill-defined. Children in intact two-parent households have overall best outcomes, followed shortly thereafter by children in equal or near equal households. As written, this bill incentivizes behavior for those who have chosen not to have the father or the child involved. If the father has willingly chosen not to be involved, that's fine. Go ahead and proceed them. But if they want to be involved, they should not be penalized for that. Simply ordering the payment of child support from the point of conception in no way encourages the parents to either reconcile or come to an agreement that works for both of them, which is best for the child. As written, the bill does not require a paternity test. It notes acknowledgement, which is fine. If you acknowledge that the child is yours, that's fine, but there should be a requirement for a paternity test. Child support is a very real problem, and if we are going to put men into debt from the point of conception, there should be a requirement that the child be his. Arrearages are a huge problem for child support obligors, and a bill like this has the potential of harming that parent-child support relationship. Child support, as calculated in Texas, is well out of date, and only one of 2 states in the union who do not consider both the parent's income or a difference in the timeshare between the parents. In addition, at currently, the child support arrearages sit at 6% interest on unpaid child support. As I understand in the bill, this is charged as additional child support. These arrearages may never, in fact, be repaid due to constant accrual of these. You are literally putting somebody in debt right off the bat. This, in turn, will affect the child's relationship with the father because of potential negative enforcement actions by the Office of the Attorney General, such as license suspension or revocation, seizure of assets, fine, penalties, jail time. Any one of these have the potential of harming the parent-child relationship, which in turn harms the child. While life may begin at conception, a child requires the support of both parents to optimally develop. Additionally, the calculation of child support at 20% of the father's income, in addition to the medical costs for the mother and the child, seems a bit unreasonable when the child does not have the same needs as a child outside of the mother's womb. Along with this, there are no guardrails on the equitable portion of all prenatal and postnatal healthcare expenses. In intact families, parents have to come to an agreement regarding healthcare expenses due to a variety of factors. This would hand sole decision-making authority to one individual. It may not be appropriate for the father to have to pay, for example, out-of-network expenses if the mother has chosen to seek an out-of-network provider when there was a potential in-network provider. Child support is not the same thing as supporting a child. I share custody with my son's mother, and he does not lack for anything, despite the fact that I do not pay child support directly to his mother. This fosters a healthy relationship between the two of us, and not based on the exchange of resources, but us putting our son at the forefront of it. This bill will not help children. If you want to draft legislation that is in the best interest of the child, we should work on legislation that reforms child custody, such as equal parenting, which once again results in second best outcomes behind intact two-parent households, and engage in child support reform that accounts for the changes that have occurred in family formation over the past 40 years. And with that, I conclude my testimony. I'm happy to take any questions.
Any questions of Mr. Champagne, members? Not hearing any. Mr. Champagne, thank you for your testimony.
Thank you.
Thank you for being here. That seems to be all the witness affirmations that I have. Is there anyone else here who would like to testify for, on, or against House Bill 1980 and its substitute? Not hearing any, the chair recognizes Representative Hicklin to close.
Thank you, Chair. I close.
All right. Thank you, Ms. Hicklin.